Court is now in session.
Welcome to Federal Rules of Evidence with Professor Pure. I am an actual law professor, kind of. I teach in a university in China. I teach legal English. I am a trial lawyer by experience. I was a criminal defense attorney in Texas for 5 years. I worked in a public defender's office in San Francisco for 3 years after that. And the rules of evidence have always been my strength as a lawyer. And when you go to law school, there's a lot of, well, there are things that they tell you that are true, which were not true for me. So, for example, I was told that the practice of law, unlike the movies, is basically boring. That was completely the opposite of the truth for me. My practice made the movies look boring. It was the wildest thing I ever did in my life. And that is true of a lot of public defenders and criminal defense attorneys. I remember when a friend of mine retired, she said, if I live to be 100, I will always introduce myself by saying, I used to be a public defender. And that's absolutely true. A lot of the law is boring. And if you want to make yourself absolutely bored to death and waste your life in order to pay a mortgage, a law degree will let you do that. But if you want to go out and have the wildest ride you can have in any life, criminal defense and trial law is the way to do that. Another thing that was told in law school is they say, well, you know, we make you sit down for these tests, like you have to know the law and be able to recall it all in a moment. But the truth is that you're going to be able to sit at your desk and think about these things, and then you'll be able to make a fully researched opinion, and that's really what lawyers do. That was another thing that was not true for me. I think that probably is also true for a lot of lawyers, that they actually don't have to know the law off the top of their heads. That's not true for trial lawyers. Trial lawyers need to know the law off the top of their heads. And I was once called, or trial lawyers, criminal defense attorneys, are sometimes called gunslingers. I'd been a lawyer a long time before anybody called me a gunslinger. But I immediately understood what it meant. A lawyer is often called a young gun, because the art of being a young lawyer is often called a young gun, because the art of lawyering involves being able to think about a complex issue very quickly and to respond rapidly with accuracy and timing. And that's mainly what the rules of evidence are about. I would say that if I could teach only one class in a law school, it would be evidence. Because everything else you can learn. Everything else you can go to the textbook and you can figure it out, and you can take your time whenever to make a decision. But evidence, you have to have it at the ready in order to use it effectively. And so that's what this is about. And when you learn the rules of evidence, you learn them in a different way. You learn them not with the idea that, well, I'll be able to go back to them, but you have mnemonics, and those mnemonics you keep for the rest of your life, and you have not even mnemonics, but the structure of the rules have to be just hardwired into your brain until it becomes second nature. And I think that what we do in VRChat Drama Court is about wanting to simulate that. When I ask my law students, why do you want to be a lawyer? Very often they say to me, well, I've seen lawyers in TV shows. And since I teach in China, they say, I've seen lawyers in Hong Kong TV shows. But the lawyer, you know, puts on the nice suit and looks so great, and they're absolutely in control of their surroundings, and there's chaos all around them, and they're just this force that just cuts through. Well, that's what the rules of evidence allow you to do. And so the art of evidence is basically the art of lawyering. Now, In law, there are 3 dimensions plus time. So just like in physical reality, I mean, there may be in physical reality, who knows how many dimensions, 21 says string theory, whatever. But we experience in physical reality 3 spatial dimensions plus time, right? We can go forward, back, we can go left, right, and we can go down. And if you want to understand your position in physical reality, you have to know something about all 3 dimensions. You don't necessarily have to know everything down to the tiniest atom, but you have to have a pretty clear picture of where you are in all 3 dimensions and where you want to go in order to move. And then you have to add in time. Law is like that. It has 3 dimensions. And what that means is that whatever situation you're in as a lawyer, whatever you're doing that day, you have to keep in mind 3 entirely, mostly separate ways of looking at your situation. The 3 ways of looking at your situation are substance, evidence, and procedure. Okay? Substance is the law as most people really should know it. Of course, most people don't know the substantive law either, but that's the idea, that philosophically, people should know the substance of the law. They should know that murder is a crime. They should know if they're in a particular industry, what it is that's legal for them to do and what it is that's not legal for them to do. The substance is the do this, do that of the law, and if you do that instead of this, we're going to do this other thing to you. Okay? That's the substance of the law. And that be kept in mind at all times, obviously, because it governs what you do every minute of every day. But that's only part of it. And the rest of it is the domain of the lawyer. Actually, the substance is the domain of the lawyer too in practice, but in theory, substance should be the domain of everyone. But matters of evidence and procedure are the domain of the lawyer. Substance is the world as the law wants it to be. It is a picture of the law's ideal world. And I say the law's ideal world because it's not our ideal world. The ideal world that the law wants is a shitty world. I do not recommend it. But the law has that picture. What is the law? Does the law actually think? Well, not exactly, but you can think of it as an entity, as an organism. Evidence is the way the law sees the world as it is. The law understands that the world is not as the law wants it to be. Sometimes the world is different from the way the law wants it to be in ways that we would probably agree are better. Sometimes in ways we would probably agree are worse, but different. Evidence is a way of processing information. So the rule about substance is this. This was said by Holmes, son of a bitch, not worthy of a statue, but yet he has a bust in my university. We do not deal in justice, we deal in law. That's a substantive statement. You could make an evidentiary statement to go along with it. You could say, we do not deal in truth, we deal in evidence. Evidence is a way by which the law thinks. And you can think of evidence functioning in the law in exactly the same way that a computer program functions. As a matter of fact, a courtroom is a computer. The first machines were made out of people, just like the first earth movers were bunches of slaves that hauled big bricks, and just like the first tanks were bunches of soldiers who held shields in formation. The first machines were made out of people. The courtroom is a computer made out of people. And for purposes of, and the function of the courtroom is to do exactly what a computer does. What does a computer do? It processes information. It has subparts that are designed to help it process the information. And I think this metaphor is going to go over probably a lot better with the VRChat crowd than it might with students who don't necessarily build computers like we do, or play with computers a lot like we do. What does your computer have? It has a central processing unit. The job of this is to take information and do whatever it is a computer does to turn it into other information. How it does that is mostly a mystery, but we know that it does it. Well, a courtroom is a computer made out of people, and a courtroom has a CPU. And that person is called a judge. The CPU is the judge. Their job is to process information. Okay? A computer also has storage, ROM. Courtrooms also have storage, ROM. These are called witnesses. Their job is to hold information until it is then brought and directed to the CPU, to the judge. And just like your computer has a system which is designed to move information from the storage to the CPU, called RAM, the courtroom has a system that's designed to move information from the witness to the judge. It's called a lawyer. That's what we're here to pretend to be, the RAM of a computer made out of people. And then, since we're all here in VRChat, we all know that there is another part of the computer, which is not part of every computer, just part of every computer that is good. The expensive, cool part, the graphics card, the GPU. Courtrooms, likewise, sometimes have graphics cards. They're called juries. A jury is like a judge in that it thinks, in that it processes information, but different from a judge in that it processes a more specified kind of information. Now, some computers have integrated graphics, meaning they don't have a graphics card, but the CPU is designed to do some of the job that the graphics card would do. And of course, they don't do as good a job as if it had a graphics card, but they can get by. Okay? Some courts are like that. Most courts in China are like that. In the United States, that is true for probably the majority of cases, but not in the case of a full dispute. In the case of a major dispute, the norm in the United States, the law in almost every case in criminal cases, and the norm in a large but shrinking number of civil cases is to have a jury. And their job is to think about a particular kind of thing. Well, what is it that they think about? They think about basically the same thing your graphics card thinks about. Their job is to create a sense of what happened, to create a clear picture of reality. That's different from what your CPU does. Your CPU makes decisions, and the CPU may make decisions about what information to send to the GPU. It can be a gatekeeper. And the judge is that to the jury. The judge is a gatekeeper of information. Now, in an adversarial system, which is what we have in any part of the world that has ever been part of the British Empire, and really to a lesser extent everywhere else, the lawyer is, at least to a large extent, loyal to one side of the party, one side of the case. They take a position. And typically they are paid by one side or the other. Occasionally lawyers are paid by the courts, but generally they are paid by one side or the other. Or if they are paid by the court, very rarely is that permitted to affect the way they think. So in the case of a criminal defense attorney, we take money from the court, but we are expected to pretend as if the money came from the person we're actually representing. So we are then designed to handle these cases in a way which is adversarial, combative. We are to be opponents to one another. And the idea is that when both lawyers do their job well, they should cancel one another out, and that as a result, the justice, or not justice, but the substantive law should triumph. Okay? Now, evidence is the way that information is turned into something which can then be considered by the computer. And for purposes of simplicity, I'm going to assume that we have a jury. Assuming we have a jury, the purpose of evidence is to take, of the law of evidence, is to take information and filter it out, sort through what the jury gets and what they don't get. And who makes that decision? The judge. Okay? So that's the basic structure of how this works. Now, the law of evidence is different according to jurisdiction, and I'm going to be talking about the United States because the United States is where I'm a lawyer. In the United States, we have 50 states, and we have a federal government, and there may be other territories with sub-governments there, but generally those are run under the federal system. Now, almost every state uses a system of evidence which is based on the federal system. There were questions in earlier times of legal history where the rules of evidence were not codified. If you ever heard my lecture on the history of the common law, you know that in the beginning of the common law, back in 1066, basically nothing was codified. And little by little, the common law, which is the process by which judges just basically make up the law, was supplanted by codes. And I said codes in that case because that's not exactly what the rules of evidence are. It'd be more accurate to say positive law. There's a difference between rules and a code. The difference is that a code is a big enough book that if you hit somebody in the face with it, it would break their nose. And rules are a small enough book that if you hit somebody in the face with it, that they might hit you back. Whereas principles would be just a couple of pieces of paper, and if you hit somebody with it, they would just flip you off. Okay? The federal rules of evidence are based on rules. They are small enough that you can memorize them, but large enough that you have to take a class and have a bit of a specialized education in order to do so. That's how the federal rules operate. Of course, it's a law. It's passed by the federal legislature, but it was really written and decided by the courts, by the United States Supreme Court elsewhere. All right. Now, every state, except two that I know of, has taken the federal rules of evidence and made little changes here and little changes there, and then said, all right, now that's the Texas rules of evidence. All right, now that's the Colorado rules of evidence. The two exceptions to this are California and New York. California runs on a code, meaning the evidence code is in California big enough that you could break somebody's nose with it. Whereas in New York, it runs the other way. The New York evidence system runs on principles of common law, which in theory means that it's incredibly simple, but in practice, of course, means it's outrageously complicated because it's all decided and made up by the judge. But in both cases, California and New York, the basic principles of the federal rules of evidence apply. Therefore, if you want to know the law of evidence as it exists, you go and you read the federal rules of evidence. And you can find this. Just head to your DuckDuckGo is what I use, and type in federal rules of evidence, and you can head to I'm looking at one here, https://law. Cornell, cornell.edu/rules/FRE. And that'll take you to the complete and updated list of the Federal Rules of Evidence. And it has 11 titles. And we're going to be spending some time on each one. This is our basic introduction class. We're going to explain how this functions. If you were to instead go to your search engine and type Texas Rules of Evidence, Florida Rules of Evidence, whatever, it would probably take you somewhere that would look a lot like the Federal Rules of Evidence. And if you were to line up the Federal Rules of Evidence right next to, let's say, the Texas Rules of Evidence, you would have to look really closely before you could tell that they were not exactly the same thing. Okay? So, therefore, when evidence is taught to law students, the Federal Rules of Evidence is what we teach. And when I teach evidence to my Chinese law students, it's the Federal Rules of Evidence that I teach. And when you take evidence in first-year law school, you're going to be learning the Federal Rules of Evidence. That, therefore, is what I'm going to be teaching. For purposes of VRChat, well, first of all, a lot of the games we play in VRChat are with people who don't want anything to do with the rules of evidence because, it's just a game, and not even a game, but just wild play. And that's fine for them, but we know that there's a small subculture of people who try to take these cases and make them operate as would a real courtroom, and that's who I really expect will make up most of the people who come to my class here. So, therefore, we're going to be moving on with that. Okay. So, that brings me to the idea of rulings on evidence. And if I've got my Federal Rules of Evidence here, we can see 101. We don't need to mess with 101 right now. We may need it later. But before we find the rules, we don't really need the definitions that go in the rules. The purpose of the rules, this is something that I have never actually used. Maybe I should, but I've never heard any other lawyer use it. It says, 102, these rules should be construed so as to administer every proceeding fairly, eliminate unjustifiable expense and delay, and promote the development of evidence of law to the end of ascertaining the truth and securing a just determination. Does that mean, wait, but Professor Pure, you just said we deal in evidence, not truth. Didn't you just read 102, and doesn't it say that the point is to ascertain the truth and secure a just determination? Doesn't that mean that we deal in truth, not evidence? No, it doesn't. What it means is that this purpose statement is there as a way of resolving ambiguities. What I mean by that is if you read something elsewhere in the rules and you don't know what something means, and you've got one way of understanding it that involves ascertaining the truth, and another way of understanding it that doesn't, then maybe the right way of understanding it is the way that ascertains the truth. But if you read something in the rules of evidence, and you know what the rules of evidence are saying, and it's in such a way as does not effectively ascertain the truth, does that mean we don't have to follow that rule? No. You still have to follow the rule. The purpose statement is there in order to help judges understand how to resolve ambiguities. It otherwise has no bearing. It doesn't do anything. In fact, the purpose statement, I just spent more time on it than any law professor I ever knew. So give it not much significance. Now, I want to talk about Rule 103 because that tells us really what I think you're here to learn. You're here to learn, I think, how I can make an objection in VRChat Drama Court. Well, that's the subject of the whole course. and this is just the first day. We're going to be working out the exact timing for when we'll do the rest of the course, but this being the first day, I'm not actually going to tell you what is or is not an objection yet. We may get to it by the end of the hour, we'll see. But Rule 103 gives you the basic structure for how courts process objections. Let's go back to the computer metaphor. Information comes in to the court. And it can come in a variety of forms, but usually it comes in the form of witness testimony. That is to say, a witness comes up, says, "I swear to tell the truth, the whole truth, and nothing but the truth." A lawyer asks them a question. They answer the question. Their answer is written down by somebody called a court reporter, and then that is information. Notice I didn't say evidence, information. As this happens, the lawyers should be sitting there listening to the question, mostly the question, to a lesser extent the answer. And they should be considering the rules of evidence, which I'll be teaching throughout this course. As they do that, they're going to say, that violates Rule 401. That violates Rule 603. Whatever. Now, of course, when the lawyer says this violates that rule, it may or may not, because the lawyer is not neutral. The lawyer's job is not to help the judge find the correct legal outcome. Okay, that's technically one part of the lawyer's job, but it's not what they're expected to do. They are expected, at least in the short term, to support their client within the bounds of the law. That doesn't mean that they go around and object constantly to every single thing, even if they have no basis for the objection. You have to have a basis for the objection. But having a basis for the objection is not the same thing as being correct. To have a basis for the objection means that you are not just throwing out word salad. So a lawyer has a professional obligation, and I, a while back, taught a class on the rules of professional responsibility. And I said in that class that you have an obligation to refrain from making what are called frivolous arguments. Well, an objection is an argument, which means that a lawyer has an obligation to not make them frivolously. What's a frivolous objection? Well, basically, it's an objection that is so way off that you know perfectly well that no one but a complete idiot could even think that that is an acceptable argument. And it's really difficult to actually make frivolous arguments if you know the rules of evidence and you're not just having a stroke throwing out word salad. This is particularly true in criminal cases, because in criminal cases, at least on the side of the defense, it is the right of the defendant to demand strict proof of all accusations, even if doing so would otherwise be frivolous. What do I mean by this? I don't care how guilty your client is. It's never frivolous to plead not guilty. I don't care how strong the evidence against your client is. It's never frivolous to say they have not yet proven it beyond a reasonable doubt. Defense attorneys have this added protection to allow them to do their job. But even if you're not a defense attorney, you still have a wide range, because the rule of frivolous pleadings and frivolous arguments says that an attorney may argue for a reversal, modification, or expansion of existing law. A reversal, modification, or expansion of existing law. You know what that means? It means that if you know that the law is absolutely against you, and you say, "Judge, the law is absolutely against me, but you should change it anyway," that's arguing for a reversal. And that's not a frivolous argument. If you know the law is mostly against you, And you just think, well, you should change it just a little bit. I know it's mostly against me, but just change it just a little bit. That's not a frivolous argument. You can do that. If you know that the law doesn't really say whether you win or lose in this case, but you could kind of imagine this other part of the law growing in such a way, that's fine. As long as you tell the judge what the law is that you want to reverse, modify, or expand, it's not frivolous. And that means that objections can be made. The term is in good faith. Making a lot of objections is something which is most commonly done by young lawyers. When I was a young lawyer, I objected so much the judges hated me. But it was necessary, I felt. This is in the idea of if you compare a lawyer to a gunslinger, if you compare a lawyer to a soldier, this is the idea of being trigger happy. That, in war, in battle, the rookie is the one shooting, whereas the expert is the master is the one taking their time and so on. Well, young lawyers tend to object a lot. Why? Because the punishment for not objecting is the client suffer terribly. The punishment for objecting, as long as it's done in good faith, and it usually is basically nothing. Except that if you object too much, the jury may decide that they don't like you. That is not that big of a problem. I know it sounds like a big problem, but if you know how to manage it, it's not that bad. What you do is during jury selection, you come in and you perform a defense attorney technique called taking the sting out or disclosing your insecurities. You say to the jury, to the potential jury, while you're allowed to do this, ladies and gentlemen, I object like crazy. I know you've seen TV shows where lawyers are always objecting, and it's usually the bad guy who's objecting. But I do it because if I don't do it, my client could go to prison, and it could blow back on me. It could be my fault. And therefore, because I'm young, because maybe I'm not the best lawyer, go ahead. Tell them you're a bad lawyer when you're a defense attorney. Go ahead. It makes you a good one. Don't recommend this necessarily to prosecutors, but it's a good and commonly practiced method for defense attorneys. Therefore, ladies and gentlemen, I'm going to object a lot. And please, ladies and gentlemen, do not hold my objection against my client. Because they did, and don't say your client, by the way. Don't call your client your client. Call them by their name. First name. Unless they're way older than you, and then you can call them by their surname. But, let's say Manny is my client. Ladies and gentlemen, I object like crazy. And I know that you may think that I'm hiding something from you. What's happening is I want to give Manny here the fairest trial that I can. And I'm afraid, ladies and gentlemen, I'm afraid that if I make a mistake, if I miss an objection, that Manny may suffer and pay a terrible price. And I don't want to go through the rest of my life knowing that I made a mistake that cost Manny his freedom. But I also know, ladies and gentlemen, that if I object, you may think I'm hiding something from you. So please, ladies and gentlemen, if you think that I object too much, blame me. Hate me for it. But please don't blame Manny for it, because it's not his decision. And then you say to the jury, now, ladies and gentlemen, are you able to do that? Would you make me would you tell me, would you tell the judge, would you tell everyone in this community, would you say it on the record right here, that you would not hold my objections against Manny? And you get him to say it. And then from there, you're in a pretty good position. From there, you can object like crazy, which, okay, not like crazy, not literally like crazy, but object a lot. Now, why is this so important? Why do we do this? Well, we object for two reasons. Number one, we want to keep evidence out from the jury, but that's not the reason that we say. The reason that we say, and it's a real reason, is that we want to do something called preserving error. What do I mean by this? Okay, there was a time in American legal history when if a lawyer failed to object to inadmissible evidence, and inadmissible evidence was admitted by the judge, and the jury heard it, and the party lost the case, it was the right of the party who had lost to appeal. This led to major problems in managing the appellate system. There are still major problems in managing the appellate system. But it used to be way worse. Because what, I won't say great lawyers, but let's say sharks. Let's say major corporate fixers. Big problem solver kind of corpo lawyers who back then, I mean, today you may be working, if you're, that kind of a lawyer, you may be working for Facebook or whatever. In those days, when you were that kind of a lawyer, you worked for railroads. So if you were a fixer for the railroads, and American legal history is full of stories of railroads getting sued and trying every crazy story, every crazy trick in the book to get out of it, then what you would do is this. A case would come before you, okay, you represent railroad, and you would look at it and you would try to find a way to trick the judge into admitting evidence against your client, which was bad, maybe not so bad that you would definitely lose, but bad enough that you might lose. And then you would try the case and just maneuver just a little bit to get the other side to make this mistake. And then rather than object, you would just sit there and let it pass. Then, in the event that you lost, you would go straight to the appeals. You would go straight to the appellate court and say the lower court made a mistake. Here's the mistake they made. And the appellate court would look at that and go, oh, you're exactly right. They made a mistake. Okay, reverse and remand. That means the higher court sends the case back to the lower court and says fix it. Which means that the fixing it means, in many cases, have an entirely new trial. Meanwhile, your client, the railroad, is not paying their judgment. Meanwhile, witnesses are getting old and dying. Meanwhile, cases are going away because the people who are suing the railroads are dirt poor and they're going to take easy settlements that are cheap now rather than hold on later because poor people need money now. And therefore, you were able to really make a mockery of the system of justice. So to stop that, the rule of objections became this. Except in cases of what is called plain error. If you do not object, the courts will assume that you did not intend to object. What is plain error? It's complicated. Basically, what you need to know is two things. One, it's extremely rare. Number two, when plain error does exist, it is almost always something to do with a constitutional right. It's most likely happening in a criminal case, and it would be, something like calling the defendant to the witness stand, which, of course, violates their privilege against self-incrimination. That would be a flagrant violation of their constitutional right. That would probably be plain error. But short of something outrageous like that, plain error basically does not happen. And what that means is that if you don't object in trial, then when that case goes up to the appeals court will look at it and say, you didn't object. Therefore, you are not allowed to appeal. Now, there are good reasons why sometimes a lawyer would not object. Maybe you know perfectly well that if you object, even if you would win, the evidence would, they would just have to do something else. Like you want to say objection foundation because they have to ask this person one other question, but you know perfectly well that if they asked this person this question, they would answer in such a way as to lay the proper foundation. And anyway, the longer the other side's witness talks, the more screwed you are. So maybe you don't object. Maybe you let it go. A common answer that you hear from defense attorneys, which I pride myself on never making this excuse, but a common answer that you hear from defense attorneys to the question, why didn't you object? A common answer by defense attorneys who are trying to cover their asses, they will often say, I didn't want to call attention to it. They would say, well, you see, yes, that witness said this thing and it was bad for you, but if I said objection, then the jury would be paying more attention. And if I didn't say objection, then maybe they would just kind of let it wash over them. Well, I don't buy that in most cases. I mean, I have on one occasion actually seen a juror sleeping in court. It was not during the defense speech. It was during the prosecution speech because the prosecutor in that case was profoundly boring. But maybe that's a reason why you wouldn't object. Another reason why you might not object, maybe the evidence actually supports you. Maybe the other side doesn't know it. Maybe the other side thinks the evidence supports them, but actually you know how to interpret that evidence in your next move and you just want that evidence, so you just let it in. That's fine. You can do that. And the courts want to give attorneys the kind of license to make those decisions. If anybody's ever heard of the Twinkie defense, there was a mayor of San Francisco named Harvey Milk who was the first openly gay mayor, and he was shot. And the man who shot him was put to trial, and the defense attorneys made the argument that this person was profoundly depressed to the point of severe mental illness, and that his severe mental illness was evidenced and made far worse by a constant ingestion of really fatty, sugary foods, depression meals. And the ultimate depression meal is, of course, used to be, they don't exist anymore. The ultimate depression meal was, of course, a Twinkie. And so this defense of the man who killed Harvey Milk was called the Twinkie defense. Manny, you have a question?
The Twinkies are actually back.
All right. Well, then the Twinkie defense is back on the table. So it's been argued, so this is coming from a case, I don't know if it's actually Strickland v. Washington, but it's in the line of Strickland v. Washington, the ineffective assistance case, where it's basically admitted by the judge or argued by the judge that we, the courts, want defense attorneys to come up with the Twinkie defense. What do I mean by that? The Twinkie defense is madness, but it won. It's one of those strategies that is just crazy enough to work. We want lawyers to be free to make moves that are just crazy enough to work. And therefore, we don't have a lot of rules that involve sitting and telling a lawyer, do this, do the other. This is getting a little better in some respects, because in some respects there's been a rise of what's called checklist thinking. There's a very good book I recommend called The Checklist Manifesto, and modern lawyers are beginning to live and operate by the principles in this book, by checklist. And I recommend it. When I was part of the public defender's office, they were, things operate by checklist, and big law firms typically operate by checklist. But a good checklist is not there to make you do things. A good checklist is there to make you think. It's there to make you ask the question, should I do this? And if you say, I shouldn't do this, and here's why, then that's fine. As long as you fill out the checklist, there's no wrong answer. Almost no wrong answer. But if you make an absolutely obvious mistake, so for example, I once knew of a case where someone was charged with a crime. This person was an immigrant to the United States from Mexico, and this person had a constitutional right to have the Mexican embassy notified of their arrest, and this was not done. And there was absolutely no excuse for not notifying the Mexican embassy of this. Okay, in that case, that's an ineffective assistance of counsel. But short of obvious, boneheaded, stupid, I forgot kind of mistakes, defense attorneys do not receive findings of ineffective assistance of counsel. If you do receive a finding of ineffective assistance of counsel as a defense attorney, then you don't get disbarred typically, but it's very common if you're appointed that you have to disclose that to every other judge you ever ask to have you put on the court-appointed list, and in some counties, in some areas, that means you don't get to be on a court-appointed list anymore. Furthermore, you might get sued if you screw up for malpractice, but these cases are very, very rare, because in order to do that, you have to get not just one lawyer, but usually several lawyers to agree that you made a mistake, because who knows whether a lawyer made a good decision or a bad decision other than another lawyer. And of course, nobody's going to sue a lawyer other than another lawyer. And many lawyers like suing other lawyers because they'll be shunned. They're seen as sort of cannibals by the profession. And therefore, lawyers are basically free to operate with a free hand and to accept the consequences of their actions, and their actions affect their clients. When you screw up as a lawyer, most likely you won't be the one who suffers for it. Most likely, it'll be somebody else. And that sucks. Seeing objections is the classic way in which a lawyer can screw up. Because if you don't object, remember how I said in a courtroom there is somebody, we don't have this person in VRChat court, I wish we did. We had somebody who writes down every single word that you say. Well, they put that out into something called the record. And when you appeal based on the record. Now, this is antiquated. There is no good reason for it today. As far as I can tell, the only reason that we do this is that the court reporters have a union, and they are concerned with protecting their job security. And the courts are pretty much good with allowing them to do that because they don't really have the budget. They don't really have the technical know-how, because appeals court judges are, generally speaking, not young people. They are kind of set in their ways. And so we really could simply videotape and audio record what happens in a courtroom, and when you appeal, you simply cut that little video and you write in your pleadings, 4 minutes in on day 3, the defense said this, and you show the video and they can watch the video. That would be a way of, we don't do it that way. Instead, we do it the way we did it before there was such a thing as a video camera, which is that somebody comes and writes down every single word that you say, and they operate like a machine to the point that if the judge does not say off the record, even if the judge means to say off the record, they still don't stop. And there's a famous case in corporate history of some judge who said to the lawyers, "I know you want to argue that corporations are not people for purposes of the 14th Amendment, but I don't care. Don't talk about that," and forgot to tell the court reporter, "Stop writing it down." So we now know that this had happened. It's now part of history. That sort of thing does happen. That somebody, "Oh my God, are you writing this down?" And once it's written down, it doesn't come out. Now, I know that we all hear on TV and we hear in drama court the phrase, "Can we strike that from the record?" And yes, okay, we do actually say, "Can we strike that from the record?" But what we don't do is strike things from the record. It doesn't happen. Records must not be stricken from, ever. What you do is you just say, "I order that stricken," and then they don't actually strike it. Because if you didn't, the appeals process would be tainted. If a trial judge were free to simply remove things from the record at will, then on appeal, it would always be within their power to make the case look like they made no mistakes, when in fact they did. And there's a subtle dance that goes on between defense attorneys and judges, not just defense attorneys, but attorneys and judges. I say defense attorneys because I was one, and because generally speaking, the defense attorney does not have the sympathies of the judge. But there's a stance where the defense attorney is trying to say things that the judge probably doesn't want said, but in such a way as when you look at the record, you can't tell that that's what they were saying. And the judge likewise is trying to order the defense attorney or order the attorneys to do things or to make statements to the jury that maybe that they're not completely neutral, without looking like that's what they're doing. This is part of the layers of meaning that goes on in a courtroom, is your ability to say things so that everybody in the room knows what it is you're saying. But if anybody were to read a court transcript of what you're saying, they would go, "Well, you didn't mean that at all." This is part of the subtlety and part of the dance that lawyers go through. So you do this because when that case goes up to the higher court, the higher court is going to handle the appeal on the record, meaning they're going to say, "Give me the papers." And this act of saying, "Give me the papers," the higher court will write up a thing called a writ of certiorari, and they will pass that down to the lower court. And the writ of certiorari says, "Send me the papers." And then they will take the papers, and it will go up, and then that will make its way to the higher court, and from there they will read it. And if it happened in the courtroom, it's not in the record, it didn't happen. And if it happened in the record and it didn't happen in the courtroom, then it did happen. On appeal, we deal with what's in the record as if it is the absolute truth. There may be a few tiny exceptions to that, but very rarely. Pretty much, you appeal on the record, and that's it. And what that means is that if you take that, what I just said about appealing on the record, and you add to that what I just said about the fact that if you don't make an objection, the appeals court will assume you intended to not make an objection, and that means that if it's not on the record, if your objection is not in the record, you didn't object, and that means you lose. And that means that it is the job of a good lawyer to object in the following way. They must object when evidence is inadmissible, and we'll talk about, as this course goes on, we'll talk about what makes evidence inadmissible. But for now, understand that an objection must be three things. An objection must be timely. It must be specific. And the third thing that it must be, this part is not actually written in the law, but it must be effective. Objections must be timely, specific, and effective. What do I mean? When I say that an objection must be timely, what I mean is that it must be made, generally speaking, after the question, but before the answer. Remember how evidence usually comes into a courtroom. It usually comes into a room by a witness saying, "I swear to tell the truth, the whole truth, and nothing but the truth." And then the lawyer asks questions, and the witness answers. And I'm talking here about objections to the admissibility of evidence. There are a couple of other little objections that aren't technically to the admission of evidence, like objection non-responsive. But for the most part, one lawyer, lawyer A, is asking questions of the witness, and lawyer B is objecting. And when lawyer B makes their objection, that objection must come after the question, but before the answer. Why? Well, because the judge is supposed to rule on it. Once an objection is made, the judge will then say, the objection is good, which means the evidence is bad, and the word they'll use for that is sustained. Or they'll say the objection is bad, and therefore the evidence is good, in which case they'll say overruled. And that objection to ruling is what goes down in the record. And that record then, when or if it ever finds its way into an appeals court, the appeals court will then say the judge made a mistake or the judge didn't. Now, if you object and the judge says overruled, you have preserved error. There's a funny kind of mirror logic to this. For the purpose of preserving error, you want the judge to say you lose, because it's called preserving error. You need the judge's mistake to be clearly documented on the record, and if the judge says overruled and the judge should have said sustained, then on appeal you might have grounds for a reversal. Okay? But what if you say objection and the judge says sustained? Are you done? Well, in some cases you are. If you say objection and the judge says sustained, then you really have nothing to complain about. You won the objection. Well, there is something you might want to complain about. Because if the jury heard the judge say, heard the question, heard you object, heard the judge say sustained, then the jury may be sitting over there going, oh, the defense attorney doesn't want them to ask that question. That must mean the answer is bad for the defense attorney. Therefore, that question, had it been answered, would have been answered in a way that was bad for the defense attorney in this example. Therefore, I, the jury, will assume that the answer to that question, had it been answered, would have been bad for the defense attorney. Well, defense attorneys, and again, it's not always defense attorneys, but I'm simplifying here. Defense attorneys don't like that. You want to object, but you want to object in such a way as you don't suffer from the objection. Like I talked about at the beginning, how I come to the jury or how I would come to the jury and say, ladies and gentlemen, I object all the time. Please don't hold it against my client. Please don't hold it against Manny. That's fine. You can do it that way. But it still might not be enough. the jury might still mess it up. Or you might mess up the timing just a little bit, right? Because remember how I said at the beginning that a trial lawyer is often called a gunslinger? That's because of the issue of timing. Because you have to understand, follow the thread of the conversation so tightly that you can, before an answer is given, but after a question is asked, know in advance that the question was not legal according to this complex set of rules that we have, and say objection and nail it. Well, you might get it wrong. You might not nail that headshot timing. And that means that the other person on the stand may actually say some information that's bad for your client that is illegal. Okay? In that case, you may want to do something about that. Or even if they don't, even if you nail the headshot, the very fact that the question was asked and that you got an objection could be a problem. So what do we do about this? Well, if you get a sustained, then the next move for the objecting attorney is to say, Your Honor, I move to strike and disregard. What does that mean? By the way, I've heard in VRChat a lot of misunderstandings about this word move or motion. I've heard in VRChat judges say, I move this. Judges don't move. Lawyers move. Judges order. A motion is a request by a lawyer to a judge for an order which is other than the final order in the case. Okay? So when you say I move to strike and disregard, really it's move to disregard because, as I said, we don't actually strike things from the record. The judge will then have a choice. If the judge says, no, I'm not going to order to strike and disregard, guess what? You just preserved error. That means that, okay, you've preserved a smaller error. Because if it comes to the higher court and they look at that record and it says, objection, sustained, move to strike and disregard, denied, then you can argue to the appeals court if the lower court had actually given the motion in disregard, had granted that motion, then I would have won and it's grossly unfair or against the, you could then try to convince them of that. Now, maybe the higher court would say, well, I just don't think that damage material and you lose the appeal on those grounds, but it all depends. So the proper procedure is objection, sustained, move to strike. All right, let's say the judge says granted. In that case, the judge will turn to the jury and will say, ladies and gentlemen of the jury, please disregard that question. And the jury is then required to think in their heads, I will pretend that that question was never asked. And the jury, before they become the jury, should generally be instructed by the judge. Sometimes I, the judge, may tell you to pretend that something wasn't said. Are you willing to do that? And if they don't say yes, then they don't get to be on the jury. But, well, we're all human. And sometimes, even if the judge says, don't pay attention to that, we still do. Courtrooms are places where things happen that you don't forget. I remember, I wish I could say every time, most of the time, that a door was open or I could hear down the hall from the criminal courthouses a tortured human scream. This system be fucked up. Anyway, things happen that you don't forget. And it may be something like that. All right, well, in that case, we have another step. You say, objection, move for mistrial. Or not objection, but I move for mistrial. So it's a three-part process. I object. If the judge says overruled, you preserved error. If the judge says sustained, you move to the next step. Move to strike and disregard. If the judge says denied, you preserved error. If the judge says granted, ladies and gentlemen of the jury, please disregard, then you won, but maybe you want to take it to the appeals court and say, even though the judge did that, there was still no way. And the saying that we use, you probably heard on TV sometimes, is you can't unring the bell. Well, we do have a way to unring the bell, or at least not the way to uncrack the egg, but at least we can put in a new egg. And that's called a mistrial. So in that case, you say, no, Your Honor, I move for mistrial. Now, this will almost never happen. The judge will pretty much never grant a motion for mistrial unless what has happened is just so egregious that it shocks the conscience. But this is where you're asking the judge, you're saying, Judge, there's just no way that even if you tell this jury to not pay attention, they still paid attention, and they're still going to use it against my client. So the only thing we can do is to tell the jury to go home. And that's called a mistrial. It's not the end of the case. It's the beginning of the new trial. We take these people, what we do is the judge comes to the jury and he says, ladies and gentlemen, thank you so much for serving democracy. Our way of life would be impossible without you. You're so wonderful, and we really think that you're fantastic citizens. Thank you so much. Please get a free cup of coffee and a donut on your way out the door. And then we go back to square one and we pick a whole new jury and we do the whole thing all over again. This is very, very rare, but in some cases, if the judge does not grant a mistrial, that is reversible error. So it's a three-step process to an objection. Objection. Overruled, preserved. Sustained, next step. Move to strike and disregard. Denied, error preserved. Granted, jury shall disregard. Next step. Move for mistrial. Denied, error preserved. Granted, thank you, ladies and gentlemen of the jury, goodbye. Now you really have nothing to complain about because you've just basically changed out the jury, replaced your whole computer, or at least the graphics card, in order to fix this problem. In some cases, you have to do that. We normally see that in cases where, the defendant's right to privilege against self-incrimination has been severely hampered or something like that. By the way, there's an alternative, because everything I've been saying so far about the procedure for objecting is assuming that the other side wants to bring in evidence which is illegal. But wait a minute. A judge might make a mistake not by letting illegal evidence in, but by keeping legal evidence out. There must be a mirror image to the objection procedure. And it is. There is. It's called an offer of proof. How would that work? Let's say that we've got a piece of evidence, and let's assume that piece of evidence is legal. It is admissible. The proponent, and we'll say, let's say this is a civil case, because if it were a criminal case, then we get into weird rules about appeals where the prosecution generally can't appeal a lost criminal case, even if they should have won it. But let's assume we're in a civil case. And the plaintiff wants to bring in a certain piece of information. Say, the witness is going to testify. Got a traffic accident case, and the witness is going to testify the light was green. And so you bring that evidence in, and was the light green? And the other side says objection. And this is not objectionable. Of course they can say the light was green. But the judge says, sustained. And then the defense attorney follows up, move to strike regard. And in this case, let's say the judge says, okay, fine, jury shall disregard. And they follow up again, move for mistrial. And the judge goes, nah, denied. now two people have grounds to appeal, don't they? The defense attorney has the right to an appeal because they didn't get their mistrial granted. But also, the plaintiff's counsel has the right to an appeal because they had this extremely useful piece of evidence, and now they're going to lose the case because it didn't get brought in. Surely, they must have some grounds for appeal too. Yes, they do. But they have a different problem to solve. Because when that court reporter writes down every word that they say, if the objection was made timely, remember timely means before the answer but after the question, then when that record comes up, then the appeals court doesn't know what the answer to the question was. If they don't know what the answer to the question was, how can they say that this piece of information that the plaintiff's counsel is complaining they didn't get to bring in was any good? Maybe it would have made them lose harder. And therefore, how can the appeals court figure this out? And for this, we have the mirror image of the objection, the offer of proof. Here's what happens next. The plaintiff's counsel then says to the judge, "May I make an offer of proof?" In theory, the judge should immediately, okay, not really, the judge, but for purposes of the example, the judge should tell the jury, "Ladies and gentlemen, we'll be right back with you. We're going to head off to my office for a minute, head back to judge's chambers. Or, ladies and gentlemen, let's take an early lunch. You guys go off there, have some free pizza." And then the lawyers and the judge sit there, and the judge and the court reporter as well. And the judge says to plaintiff's counsel, "All right, you wanted to make an offer of proof, go ahead." And then the plaintiff's counsel says, "Your Honor, I believe that if the witness had been allowed to answer the question, was the light red or green, the witness would have said the answer was green." And the judge says, "Thank you very much. Is there anything else you'd like to add?" Plaintiff's counsel says, "No. Thank you very much. That's your offer of proof." And this statement by the plaintiff's counsel gets written down into the record, and now when it gets to the higher court, when the plaintiff's counsel then says there was a violation of the laws of evidence, I should have the right to a retrial because this evidence was unlawfully kept out. Now they know what the evidence that was unlawfully kept out was, and therefore they can make a decision on the appeals. Okay? Now, back to the question of objections. Objections must be timely and must be specific. When I say specific, I mean you must specify which law has been broken. You can't just come and say objection. You have to say which law has been broken. Well, the best, most specific way of doing that, and this is pretty common in California, is that they will object by number. Because these rules, or in California code provisions, have numbers. They're numbered. And you can say, objection 403, objection 602. You can do it that way. And if you have a level of specificity, great. That's not really the way I've practiced. It's not really my personal style. I prefer to do it by the concept. And that's fine. You can do it by the concept. So usually there's one word which will stand in for a given rule. And as we carry on with this course, we'll be learning what those rules are and the words that stand in for them. Objection, relevance. Objection, prejudice. Objection, hearsay. Objection, confrontation. Now you can make multiple objections in one go. Sometimes a piece of evidence actually violates multiple rules at the same time, or at least you have a good faith basis for thinking that a piece of evidence violates multiple rules at the same time, and you just string them together. So in a criminal case, pretty much every time that you say objection hearsay, you also say objection confrontation. And I think my personal record for how many objections I can string together in one is 5. Six. Objection, relevance, prejudice, hearsay, confrontation, authentication, best evidence. By the end of this course, you will know what all of those things are. To conclude, your objections must be timely, they must be specific, and they must be effective. What does effective mean? Effective means they must be loud enough that the court reporter stops writing down what's being read and the witness stops talking, and that everybody in the room pays attention to you. That's what's meant by an effective objection. And that has had us running for, about an hour and 15 minutes. And I think that's plenty of time for a VRChat court, for a VRChat class. And it's a good place to stop. Any questions?